This is my talk on building your social media defense to personal injury claims. Very excited to be here. It's my first RIMS, joined by a number of colleagues here as well. For those of you who may not know me, my name is Nabeel Peermohamed. I'm a partner in the Calgary office of Brownlee LLP. Today, I have a few things to talk about with respect to social media. First of all, why is social media important? Second, I want to talk about Mr. Armbruster. Mr. Armbruster was a plaintiff in a trial that me and associate ran in November 2023. And then we're going to talk about the impact of social media, specifically Mr. Armbruster's social media on the trial. And then I'm happy to answer any questions that you may have. If you have a burning question that can't wait the 20-minute presentation, then please feel free to raise your hand. We have a microphone runner for that. Why is social media important? So the number one reason is credibility. As I've been told by a number of senior lawyers, credibility is extremely important in personal injury trials. If the judge is not buying what the plaintiff is laying down, they're not going to be found as credible. We've seen this in a couple of previous cases. So the Latham case from 2024 here in BC basically said the court was able to throw out expert reports, expert testimony, if they were based on a plaintiff's self-reporting, and after that plaintiff was found to be not credible. So that's the first aspect. Expert reports can be thrown out or given less weight if the plaintiff is not reliable and those expert opinions are based on the plaintiff's self-reporting of pain symptoms. A second case, the Terry and Maloney case from Newfoundland, also used social media to find a plaintiff not credible, and then as a result, only awarded about 40 grand in general damages and nothing else. No other heads of damages were given awards. So that's the background of how important social media is to a personal injury trial. Let's now look at Mr. Armbruster. So, meet Mr. Armbruster. He was involved in a motor vehicle accident in September 2016. He was suing for $2 million, and we ran the trial 7 years later in November 2023. Now, what you need to know about Mr. Armbruster is he's quite the character. I've got a couple of pictures up there if you can see them. I don't think they're too racy. First picture is showing the rear end of Mr. Armbruster's vehicle after this extremely catastrophic, life-changing event where only there was a little bit of a bumper damage. Very low impact motor vehicle accident. What's interesting about that picture is plaintiff's counsel decided to put that picture in front of the judge at the bar for the full 3 weeks. I don't think it achieved what they wanted it to. For 3 weeks, the trial judge was reminded of how minor the impact was, which was very surprising, yet beneficial to the defense. Second picture. This is Mr. Armbruster taking a selfie, getting an ECG done at his request. He wanted to get a picture of him with leads on and get that ECG into evidence. That picture actually was part of their opening statement. They used a slideshow, and they used that as a picture juxtaposed to a previous picture before the accident of him crossing the finish line of a triathlon. Just to show how bad this accident was, we basically put him on death's door, obviously. But what's interesting is the medical notes made clear that Mr. Armbruster asked for this ECG, set up the camera, took the picture, and then wanted the doctor's office to submit the ECG, the picture, and the report to his legal team. This was all basically just staged, and he admitted all of this under cross-examination. He testified during direct examination with his lawyer that he could no longer work, had memory issues, could not remember names, and could not run meetings. I repeat, he said he could not remember names, could not run meetings. His allegations were disproved by his own YouTube videos. He ran an 8-episode podcast called Coach's Corner on his own YouTube channel. YouTube it, it's all public. And these sessions ran from 60 to 90 minutes long. I'm not going to bore you with all 8 videos, but I put together a snippet, 3 minutes total. Let's meet Mr. Armbruster.
The Coach's Corner. July 29th already. The summer's flying by. And I think we're in for another treat here this evening. We've got 2 leaders, both of the growth mindset sharing this evening. In that, Stan Peters is the current athletic director at Brownlee College. He's going to be sharing this evening about transformational coaching, how he's building into his coaches right now. Coach's Corner together. And in that, we've got 3 leaders sharing with us. And the theme is the car ride home and the plane ride home. Coach Ryan Walter, as we all know, has had a chance to not just play at an NHL level, Stanley Cup winner, but also coach at an NHL level. All right, guys, welcome to Coach's Corner. I'm actually in North Saanich, Vancouver Island. Coach Ryan, can you kind of cap some of these themes and words, something that might be on your mind right now that you might leave us with? Dave, thanks again for sharing. Appreciate you, and I appreciate your honesty. Ryan, I just want to say thanks. What a rich time together, and for everyone else making time to be a part of this call. As we look to the future, extremely excited to hear Jamel share with us in the future about his program and what he's seen in America, how they're working to develop athletes, whether it's in the weight room, away from the weight room, how they're looking at the recruiting process. Can't wait to listen to you, Jamel. Welcome to Coach's Corner. I think we're in for another interesting discussion time together. We have Gene Wolverton committed to share this evening. Gene Wolverton's a good friend from many years ago. Has had a chance to coach basketball at a high level, coached in the ACAC, and along with all the other past coaches we've had, Gene Wolverton has a growth mindset. And a hero of mine. It's been great to connect with Gene over, I guess, the last 3 months here. A lot more since our time in college. So, Gene, great to have you on the call. We also have my younger brother, Paul Armbruster, another hero of mine, and Paul's going to be sharing with us as well. I believe he's got a commitment a little later in the call. So Paul's going to share first. And in that, really looking forward to listening and learning. Gene's going to be challenging us about the story that we're telling ourselves. The theme is the story you tell yourself is often the story you believe. Gene, really looking forward to learning from you there.
The story you tell yourself is the one you tend to believe. Those are parting words from Mr. Armbruster. Keep those in mind. It's not a lie if you believe it. Okay, so let's look at what the impact of this social media had on Mr. Armbruster's case. Specifically, you can see in the video that he can run meetings 60 to 90 minutes in length, basically between 2020 and 2021. The court found he had no visible discomfort, physical, mental, or emotional symptoms. He remembered many names and events, and you could actually catch him planning ahead, planning further podcast episodes and advertising them in his sessions. Pretty functional. So now these are direct quotes from Justice Wilson in the decision. And so with respect to credibility, his social media postings revealed an individual who was not physically, mentally, or emotionally unable to participate in activities at all, and was, in fact, excited, engaged, and enthusiastic when working with other people. Another quote, the plaintiff has significantly misrepresented the situation under oath. Another quote, this is a case of false testimony. Another quote, I am satisfied that the plaintiff was untruthful. My favorite quote, I don't believe what he says. Then when we get to the expert's testimony, he had 12 experts lined up. All their expert testimony was thrown out. Justice Wilson says, I have found the plaintiff to not be credible or reliable. It necessarily flows that the various opinions or diagnoses of his experts that he relies upon in this trial are, in fact, unreliable from the judicial perspective. And as a result of this, there was no loss of income or earning capacity claim awarded. His $2 million claim from 7 years of chronic pain ended up with $1,500 in his pocket. And of course, I think his lawyer took it home. So my recommendation, any claim is worth a $500 initial social media search. In fact, the Legal Education Society of Alberta has said to all lawyers, don't be a Luddite lawyer. Plaintiff lawyers, do a social media search. Find out what your client is up to. Defense, do a social media search. At least find out what's out there so you can use at cross-examination. I'll now field any questions.
Can you explain how he wound up with 1,500 at the end?
The question was, can I explain how the plaintiff only ended up with $1,500? So the plaintiff's overall award for general damages, special damages, and a minor crown claim with interest added up to about $114,000. If you added all of the plaintiff's costs to that, you get about to $370,000 because they had $122,000 in disbursements from their 12 experts. A month before trial, we, the defense, made an offer of $400,000 all inclusive. And because it's a formal offer, if we beat it at trial, which we did, they don't get their costs, we get our costs. And so our costs were about $150,000, which wiped out all of his award. But the court thought that there might have been some trial preparation before issuing the formal offer. So $1,500 was awarded to the plaintiff for some trial preparation before the trial. So we got something. Yes?
I'm the risk manager for the city of Winnipeg, so we have our own claims department that we investigate personal injury claims, and so vast majority of them are sort of anywhere from $10,000 to $200,000 in damages for sort of trip and falls, slip and falls, things of that nature. Can you just comment sort of on the ethics of sort of collecting, this is sort of a juicy example. Somebody's putting out YouTube videos and things like that, but if just sort of doing the detective work and obtaining photos off of Facebook or whatever it might be that aren't so easily accessible.
Yes. The question is, what are the ethics to invoke during a social media search or that kind of online surveillance? So we use OSINT, Open Source Intelligence. So Mr. Armbruster's Facebook, Instagram, LinkedIn, YouTube videos, it was all open, it was all public. He didn't put any privacy settings. So the ethics are, as long as it's public, no problem. As soon as you start posing as a friend or a friend of a friend, and you try to get behind privacy settings, or you try to use that kind of clandestine effort to get social media that the author intends to be private, then you're veering into the realm of unethical collection of social media material. And so when you use an investigator, they are trained and knowledgeable on the ethics of social media content gathering. They're not going to use the unethical approach of getting behind a firewall or getting behind privacy settings. They're only going to give you publicly available information. And so most plaintiff lawyers, I think, warn their clients, beforehand, you should always have your stuff private. But if it's public, it's up for grabs. Yes?
The judge in any way, shape, or form sympathized with the decision based on the audio videos? And did they sort of stretch that out and say, well, they have breakdowns?
I think so the question was the judge sympathetic to the quality of video that was being put out? I think it worked against him. So one of the allegations Mr. Armbruster made was he wanted to be a hockey coach. He wanted to sort of quit his job in the oil and gas field and one day become a hockey coach in the NHL. And he said that as a result of the accident, he was removed from the hockey community. But who did he have on that video? Dave Hunter. Very famous Stanley Cup coach winner. And I don't know much about hockey. And my colleague doesn't know much about hockey. But Justice Wilson knew a lot about hockey. And he joked with the defense and said, "You don't know who Dave Hunter is?" He knew who Dave Hunter was. And as a result of that other allegation, I've been removed from the hockey community because of this motor vehicle accident. Even less sympathy from Justice Wilson. If you read the decision, no less than 20 times does Justice Wilson use various synonyms to call Mr. Armbruster a liar. I've never seen that before. Well, thank you very much. Appreciate your time. If you have any further questions, feel free to give me a call, shoot me an email. We're also at the Canadian Litigation Council booth just over there. I'm told it's booth number 217. Thank you very much. Appreciate your time.